learned senior advocates, past presidents, distinguished colleagues, may I introduce the panel for this session. Mr. Tunde Busari, Senior Advocate of Nigeria. Mr. Etigwe Uwa, Senior Advocate of Nigeria. Mrs. Dorothy Ufot, Senior Advocate of Nigeria. Dr. Rosemary Chikwendu. Mr. Chikwendu Madumere. The following are judicially noticed: that justice delayed is justice denied. Our courts are inundated with more cases than our overworked and underpaid judges can handle. ADRO has come to stay. It has been shown to be gaining recognition as parties continue to use it for different disputes. With over 36 court-annexed ADRO centers, we can see that it has been embraced by our courts. The question remains, can we do more with it? Or better put, can we use it more effectively and efficiently in the dispensation of justice? Today, we have gathered the experts to tell us what is possible and how we can go about it. This panel will be moderated by an astute dispute resolver, Mr. Tunde Busari, Senior Advocate of Nigeria, partner at Akunwumi and Busari. Over to you, please, sir.
Thank you very much. Do you want me to come over there? Good afternoon, distinguished ladies and gentlemen. I know it's late in the afternoon, but I need to get a response to be sure you can hear me. Good afternoon, ladies and gentlemen. Thank you very much. And I congratulate you for being patient enough to wait for this session. Delays in the administration of justice, are ADR mechanisms the answer? I say congratulations because you have a galaxy of speakers and participants, people that are known in the domestic sphere and also internationally as arbitrators, mediators, and dispute resolvers. Without any argument about it, there has been delay in the administration of justice and it's become very worrisome. And this is caused particularly due to the high number of cases that are pending in courts. This session will explore all the diverse methods of dispute resolutions that are either seen as alternatives and that are complementary to the national courts in the administration of justice. I will give a brief introduction of our speakers, but I'm sure you can read about them on the WOVA app. I'll start with Mrs. Dorothy Udeme Ufot, Senior Advocate of Nigeria. She's the founding partner of Dorothy Ufot & Co. As the title goes, she's an astute litigator. And at the same time, she's a very, very prominent and strong arbitrator, domestic and international. A member of the Chartered Institute of Arbitrators, and she's the chairman of the Arbitration and ADR Commission of the ICC. I think if I round it up by saying she's the winner of the African Arbitrator Award year 2020, she needs no further introduction. Thank you very much, Mrs. Dorothy Ufot. SM. Mr. Etigwe Uwa, Senior Advocate of Nigeria. Conferred with the rank of SCN in 2009. She's a fellow of the Chartered Institute of Arbitrators. He has done so many international arbitration cases. He has acted in very complex arbitration and insolvency cases. A graduate of the University of Lagos, a graduate at the postgraduate level of International Relations and Finance from the Fletcher School at Tufts University, Boston. And to crown it, is currently pursuing an MSc in taxation. Mr. Etigwe, thank you very much. Next is Mr. Chikwendu Madumere, a graduate of Obafemi Awolowo University. He has won so many academic laurels and prizes. Called to the Nigerian bar many years ago. He has a postgraduate diploma in international commercial arbitration from Keble College, Oxford University, and is a fellow and a chartered arbitrator of the Chartered Institute of Arbitrators. He has a master's degree in petroleum law and policy from CEPMLC, University of Dundee, Scotland. Managing partner, Madumere and Maduere. Thank you very much, Mr. Chikwendu Madumere. Last and not the least, Dr. Rosemary Chikwendu. Called to the Nigerian bar many years ago, holds LLM in international commercial law, pursuing a PhD in legal studies in mediation and dispute resolution. An awardee of 2 doctorate degrees and 2 ambassadors for peace, founder and partner in Chikwendu and Chikwendu, a firm of legal practitioners, mediators, and arbitrators. She has played a major role in the development and launch of the International Bar Association Legal Aid Handbook. She's an ADR consultant and trainer to the United Nations Office on Drug and Crimes, part of the development of the UNODC ADR training manual. Thank you very much, Dr. Chikwendu, for honoring us with your presence. Now, so that we don't waste too much time, I'll just go into a bit of ground rules. We'll give each speaker between 10 to 12 minutes when questions are posed to them. When that is done, we'll have 25 minutes of Q&A from the audience and from the participants on the Wova app. And as much as possible, we'll try to optimize our time. While standing, even though I would have loved to sit, may I pose the first question to Mr. Etigwe Uwa, Senior Advocate of Nigeria. Remember, the title of this session is Delays in the Administration of Justice. Our alternative dispute resolution mechanism is the answer. And what the speakers will seek to do is to let you know the dynamics of ADR, why we have problems in the national courts, and why or why not ADR may be the way out or may be the answer to having a more efficient justice delivery system. So, Mr. Etigwe, what are the major factors that contribute to the problem of slow administration of justice in Nigeria? And will ADR be an answer to the problem that we are faced with in the national courts? You have 10 minutes.
Thank you very much. Good evening, everybody. I think the issue, the reasons why we have delay in the administration of justice is something that we are all very familiar with. I do not intend to spend too much time on it, but we know that the sheer volume of the cases is so much Nigeria is a very litigious country. We know that we have inadequate judicial officers. There are poor facilities. Judges and magistrates are still writing in longhand in some places. And this issue of preliminary objections is something which I think has been severely abused. Sometimes when lawyers want to keep matters in court, they'll file an objection, whether meritorious or not, and they will stretch the litigation process all the way through the appellate courts. And then sometimes we have judicial officers who sometimes don't turn up in time, sometimes don't even turn up at all, even when sometimes you come from outside jurisdiction. Now, it also appears to me that there are certain things that, there's certain ways in which our jurisprudence encourages delay. One of it, I'll give an example. In the 90s, the Supreme Court held that you can file an appeal even if you have not sought leave, and then bring a subsequent application, regularize the appeal, and the appeal will be deemed to have been properly filed. In recent times, the Supreme Court has departed from that, and they say that, look, if you didn't get leave before filing the appeal is bad. So sometimes you will be in the appellate process for 5 years, and then you are told that your appeal is incompetent and you are sent back, and you start all over again. So sometimes we have transfers of judges, elevation of judges to the higher courts, death of judges, and matters will have to start de novo. Now, another example of the way the effect of our jurisprudence on delay is that if you look at the Criminal Administration of Criminal Justice Act, there was an innovation to introduce a situation where if a judge is elevated to a higher court, he can come back and finish part-hard matters. But our Supreme Court says that that is illegal and that can't be done. All of these things add to delays. Many things have been done to try and reduce delay, including front-loading, including consolidating preliminary objections with substantive matters, but we still have a lot of delays. Now the question is, will ADR be the answer? My answer is no. ADR will not be the answer. ADR can be one of the answers. And I think that if we're going to deal with the issue of delay in administration of justice, we need to revise our cost system. When people know that they can go to court and file frivolous actions, they can delay, they can apply for adjournments, and you don't impose punitive cost on them, they will continue to do it. So I think the time has come for us to adopt the practice in the UK, where if you lose a case, you not only pay the cost of your own lawyer, you pay the cost of the other lawyer. So by the time we start awarding costs, of 20 million naira, 30 million naira for some very, very important cases, people would sit up and they will learn to do the right thing. There are many other things that I think we can do. The Supreme Court is so congested. And those of us who are in practice, we know that it takes a long time for you to have your appeal listed in the Supreme Court. And there are many things that contribute to this. For instance, there is pressure that is put on the Supreme Court because of the rules relating to elevation to the bench, the rules relating to appointment of senior advocates of Nigeria. So you find that sometimes when people have bad cases that they can settle, they don't want to settle it because they want to meet the numbers, because they need the numbers to progress to the next stage. So there are many things that are factors that affect delay in the administration of justice. But I think that there are some things that we can do in addition to ADR that can be answers to it. I've already talked about cost. I think that there are certain kinds of dispute that we should take out of the court system entirely. Disputes between bankers and customers as to charges, as to the amount of loans, they shouldn't go to our regular courts. Those are matters that our regular courts are not even very, very well equipped to handle. They are matters that the accountants and bankers are better equipped to handle. So if we can revise our arbitration laws or our mediation laws in such a way that those kinds of disputes are referred to experts who will look at it, take a decision, and perhaps limit the right of appeal or exclude the right of appeal completely. I do not think that we should have unlimited rights of appeal to the Supreme Court. I think that interlocutory appeals should not get to the Supreme Court. I think that appeals on issues of fact should not get to the Supreme Court. And then we also have the pressure that election cases, pre-election cases and post-election cases impose on the administration of justice. So you will find that from now, for the next 2 years, the courts will be so stressed because they are dealing with pre- and post-election matters. And the effect would be that all other matters would be kept in abeyance. Finally, I think that we have a pool of several retired justices, both of the Supreme Court, of the Court of Appeal, of the High Court. We should try and develop a system where we can have, a pool of these people resolving some of the cases that we have through a particular means. I know that we cannot do it without a constitutional amendment, but we should try and do something. Perhaps look at a constitutional amendment where we can still utilize some of these judicial officers who are retired, but who are still able. I think I should stop at that particular point and yield to my other colleagues. Thank you very much.
Thank you very much, Mr. Etigwe. We appreciate that you did not even use up to the time so we can conclude in good time, and we'll be able to listen to others. Now I'll go to Mrs. Dorothy Ufort, SAI. And the question is going to, I'll narrow it down a bit to focus more on arbitration than other means of dispute resolution. And the question goes, Mrs. Ufort, what are the challenges of arbitration practice in Nigeria, and what solutions do you prefer? I'm asking this question because arbitration is gaining ground amongst lawyers and other professionals. We find a ready recourse in arbitration in respect of various disputes. Some are appropriate, some are not appropriate, and we need some enlightenment and education on the disputes that are best suited for arbitration. Even as it concerns those disputes that are suited to arbitration, we still have challenges, and Mrs. Ufort will identify those challenges and how solutions can be proffered to those problems. Thank you very much, Mrs. Ufort.
Good afternoon, distinguished ladies and gentlemen. First, let me thank the organizers of this session for inviting me. Mr. Busari has already said it. What are the challenges that we face in arbitration in Nigeria today? In fact, that is one of the reasons why I accepted this speaking slot. The question has been the slow pace of administration of justice. Is ADR the solution? Today in Nigeria and in the rest of the world, you can hardly find a contract that does not include an arbitration clause, because there are advantages to resolve particularly business disputes by arbitration. One of those advantages is speed. It's definitely faster than litigation. It's efficient and flexible, or today we know it's supposed to be. It's less complicated, it's confidential, and privacy is assured. The arbitrators are supposed to be independent and impartial, and arbitration is often usually less expensive. And the greatest advantage of arbitration is the finality in the decision of the arbitrators. That being so, the implication of that is that you cannot appeal against the decision of an arbitral tribunal. It's final. And I'll tell you very quickly the reason for that. When you go to the Lagos State High Court, you are not in control of the judge. The judge is appointed for you. You submit yourself to the judge that is hearing that your case has been assigned to. But in arbitration, you choose your judge, so to speak, and you cannot say you are unhappy with the decision of your judge. So what are the challenges that we face in arbitration today that is making arbitration almost as less effective as litigation in the courtroom? Sadly, one of the biggest advantages of arbitration is also one of the biggest disadvantages, and that is the finality of the award. So if you face an arbitral tribunal that is corrupt, except you know the few exceptions of how to have the award set aside, then you are stuck with the award. So many parties feel they have been cheated and they have no recourse to the law. And that is one of the disadvantages. All over the world, this has become very important. It's a hot topic, and institutions and jurisdictions are trying to remedy this challenge. And what have these institutions done? I will give you an example. Many institutions now provide an opportunity for you to appeal against the decision of the arbitrator. And when we say appeal, they don't mean going to court. A lot of institutions now have an appellate arbitral tribunal, such that if you are unhappy with the decision, you file an appeal to the institution. For instance, in ICSID, you will file an application to annul the award. It is still faster than the courts. It's still within the system. I have sat on several annulment panels for the ICSID. So what that does is that another tribunal sits to hear your grievances about the award that you have been given. And if they find that the award is not correct, or you have been shortchanged in any way, then that award will be set aside. That said, it is not so easy to have the award set aside. So that is one of the solutions. And I'm happy to state that Article 46 of the Beijing International Arbitration Center provides for that. I have already said ICSID provides for that. You will all recall that in May of this year, the Senate passed the Arbitration and Mediation Bill 2022. Nigeria has not been left out. In Article 56 of the new act, of the bill, pending when it becomes an act, also provides for an appellate system where another set of arbitrators are appointed to review the award. I think that is the greatest answer that we are giving to the challenge of arbitration. Because sometimes you get an award and you know it's wrong. Sometimes you feel the tribunal has been corrupted, but you don't have an answer because it is final. So these are one of the avenues for remedying that challenge. Other challenges that we have, please tell me when my time is up. Other challenges that we have in Nigeria in particular is in the enforcement of arbitral award. I think it's easier for the camel to go through the eye of a needle than for you to successfully enforce an award. I have tried, I'm on my third enforcement. To enforce an award against a Nigerian party is the worst thing you can encounter. So, and that makes arbitration not interesting for people that want to cite the arbitrations in Nigeria. You will never be able to succeed in enforcement. Particularly once you enter the court, you'll get recognition under the New York Convention very easily. But when you begin the real enforcement, garnishee orders, it will get to the Supreme Court. And that is one of the disadvantages that we face in Nigeria. Another disadvantage is anti-arbitration injunctions. Nigerian parties, particularly their lawyers, the lawyers, including senior lawyers like me and all of us sitting on this podium, give our clients the wrong advice. We advise them to challenge every award, no matter how well that award has been written. So these are the factors that are militating against arbitration in Nigeria. Another big challenge we face in Nigeria is the time for enforcement. In other jurisdictions, particularly in jurisdictions like Singapore, the time to commence enforcement proceedings starts from when the award...
2 minutes left. You have 2 minutes more.
Starts from when the award is rendered. But in Nigeria, it starts from when the dispute arises. So, if you have an arbitration extending beyond 6 years, by the time you finish, you are statute barred to commence arbitration proceedings. There are several other, the length of time it takes for the cases to get to the Supreme Court. So that said, I will conclude that despite the challenges of arbitration, I think, in my own opinion, with the way we are trying to solve these problems, I believe arbitration is still the answer. Take a typical oil and gas case, for instance, the technicality. There is no court in Nigeria that can resolve that dispute. Take a construction case, a typical construction case. There is no court that can resolve that dispute. So the answer is still arbitration, but arbitration that the parties can levy execution or enforce and get the reward of spending all that money to go to arbitration. Finally, another challenge is the cost. The parties today complain about the cost of arbitration, and the institutions are responding to that by trying to control the cost of arbitration to make arbitration time and cost efficient. Thank you very much.
Thank you very much, Learned Senior Advocate Dorothy Ufort. I'm sure a lot of these things we're discussing won't sound germane or novel to a lot of us here. The purpose of gatherings like this is that we should remind ourselves on how properly to do it and what we are doing that we are doing wrong. And if we want our sphere, I mean Nigeria, to take the benefit of not only the activities of the national courts, but also the benefit of alternative dispute resolutions and arbitrations, there are do's and don'ts. There are rules that they abide by in ideal societies. Mr. Etigweua made allusions to a number of things that senior lawyers do and that even the junior lawyers are inheriting. For as long as we continue to carry on delaying the course of justice, for as long as there are no consequences for unmeritorious cases, and for as long as all matters, all judgments that we get, we appeal against, we will continue to have problems with justice delivery. Mrs. Ufort also came up with a number of very, very ingenious solutions. Enforcement of award. You'll be lucky to get an award in your favor, and at the same time, in record time, execute it or get enforcement. In some jurisdictions, awards are self-executory. What that means is that the moment I get an award against my client, I tell my client, we have 14 days to pay. That is how it works, and that is why it's working for a lot of people. Now, guess what? If we make arbitration and other ADR methods not worth it, we are depriving ourselves of not only jobs, we're also depriving ourselves of income. Arbitration has an advantage of, for instance, Mrs. Ufort mentioned certain specialized kind of disputes. You don't want to try or take those disputes to other means for resolution. Arbitration is best suited for them. I'm just a moderator, and I'm just echoing what has been said. But I'll call on another expert in dispute resolution who has been introduced to us, Mr. Chikwendu Madumere, Chartered Arbitrator, and he will tell us the factors that are militating against the effectiveness of ADR in Nigeria. Mind you, Mrs. Dorothy Ufort has limited our intervention to arbitration. Mr. Madumere is going to talk full-blown on the methods of dispute resolution that are alternative to litigation and arbitration. And is also going to go on to advise us on what to do to improve the efficiency and effectiveness of the ADR mechanisms in Nigeria. Mr. Madumere.
Thank you.
He wants to do his standing.
Good evening, everyone. Let me first of all say a big thank you to the organizers for inviting me to share my thoughts on the subject I've been asked to speak to. Now, we will recall that the topic for this section is delays in the administration of justice are alternative dispute resolution mechanism the answer? And within that topic, I've been asked to address two questions. Number one question is, what factors militate against the effectiveness of ADR in Nigeria, and how do we improve the efficiency and effectiveness of ADR mechanism in Nigeria? I must confess that I will make my presentation by compressing the two questions into one, because if I answer the second question, I would have impliedly provided answers to the first question. Now, by way of providing a context to this question, I want to start by saying that within the context of public international law, the right to effective remedy, the right to fair trial, the right to due process, and the right of access to justice are significant signposts to democratic governance. Now, if you look at International Covenant on Civil and Political Rights, from Article 2 to Article 46, it provides very clearly a bouquet of rights. And interestingly, Nigeria is a signatory to that covenant. In fact, Nigeria ratified it on the 29th day of July, 1993. And within the context of our national law, as lawyers, we also understand that the 1999 Constitution provides what it calls fundamental human rights. All of this speaks about access to justice. Section 6 of the 1999 Constitution provides that judicial arm is the arm of government with constitutional authority to ensure compliance and implementation of those rights, which means litigation remains the traditional means of resolving dispute, traditional means of providing access to justice to citizens. However, the law recognizes the right of citizens to contract out of this traditional means, which is where the ADR comes in. And in this context, I will speak about ADR with regards to arbitration and mediation. So how do they then aid the administration of justice? How does ADR, in other words, how does arbitration and how does mediation aid the administration of justice in Nigeria? And how can we improve the efficiency of these mechanisms in the context of this country? Now, broadly speaking, we understand also matters in court can be classified into two broad categories: civil matters and criminal matters. So speaking about how we can improve the effectiveness of ADR, we have to speak about them in the context of civil matters and in the context of criminal matters. First of all, civil matters. How does ADR aid justice administration in Nigeria? Number one, tangentially, the earlier speakers had mentioned it. Number one relates to the legal framework. The first question is, what is the legal framework that governs ADR in Nigeria? What we have at the moment is the Arbitration and Conciliation Act, the ACA in Nigeria. That law is obsolete. But thankfully, a new law has just been passed by the National Assembly. And that law reflects an improvement and reflects, gives a lot of leverage in the administration of, in the practice of ADR, both arbitration and mediation. The expectation is that that law will soon be signed to law. And once that is signed to law, it will aid the effectiveness and efficiency of ADR in Nigeria. And when you talk about efficiency and effectiveness, in what areas are we really talking about? Number one, we are talking about the areas of finality of the outcome and enforceability of the outcome. And to support this view, a survey was carried out by University of London, Queen Mary College, in 2021. It asked users of ADR, what is the main reason why they prefer ADR in resolving their dispute? And they said the main reason remains enforceability and finality. So the only way, in my view, ADR can aid us in administration of justice, ensuring that the outcome of ADR remains enforceable and remains final. Number two, how do we improve efficiency? By training. Like the earlier speakers said, the major issues we have in ADR remains the practitioners of ADR. How many of us are well informed as to the methods of ADR? Most people assume that because ADR methods are adjudicatory, a lawyer simply becomes an ADR practitioner. That is not true. ADR is an area of practice. And if you want to practice it and practice it very well, you must expose yourself to trainings. Lawyers must obtain trainings, practitioners must obtain trainings. And that is why a lot of bodies in this country and internationally provide trainings. Thankfully, our judges are being exposed continually, with regards to trainings, and that is what makes the practice a lot more efficient and a lot more effective. So I would recommend that lawyers who are interested in ADR practice should expose themselves to trainings. I don't want to mention names, but we know that without a doubt that ICC, Chartered Institute of Arbitrators, and other bodies provide trainings that are internationally, of international standard. And I recommend to us as lawyers to take time out to, to take these trainings to ensure that our practice, reflects international standards. What again is another way of improving it, ensuring that, we have logistical support, logistical support in terms of infrastructure that aids Nigeria to become a prominent seat, in process of arbitration and also mediation. And then, let me now refer to criminal matters. How do we use ADR to ensure administrative justice in criminal matters? Thankfully, the AJA, which is the new, the Administrative Justice Act in Nigeria, in section 270, has made elaborate provisions as to the use of AJA in criminal justice delivery. For instance, some people have classified this as criminal mediation, which allows the prosecutor, allows the accused person, and perhaps the victim to come to a decision as to how they will resolve, that charge. In other words, in criminal matters, the process must not lead to a conviction. Lawyers can use that facility to ensure that justice is delivered effectively and efficiently. And we have instances in Nigeria where it has been used. Government has recovered a lot of money, some from former governors, some from former MDs of banks, some from former MDs of national oil companies, in a way that allows for restorative justice. In other words, criminal matters must not lead to conviction or acquittal. So ADR, in my view, can be of great support in ensuring the effective administration of justice. So with these few points of mine, my moderator, sir, I believe that ADR can come in very good aid in ensuring the effectiveness and efficiency of administration of justice in Nigeria. Thank you very much, sir.
Thank you very much, Mr. Chikwendo Madumere. Now we have two speakers in support of the proposition that ADR might not be the absolute answer, but will make a very, very impressive and commendable improvement in the efficiency in an efficient administration of justice. When we talk ADR, I'm sure all the participants will acknowledge the fact that there are so many methods of ADR. And we don't want to take this discussion to a mundane level. That's why I'm sure the speakers are not saying MEDAP is this, mediation is this, and trying to define all kinds of ADRs that we have. But we take it that this audience is well versed and knowledgeable in all the methods of ADR. Now we are going to move on to an area that is novel to quite a number of dispute resolvers and practitioners. It's an area where only the patient can succeed, and I'm talking about mediation. You have to be really, really patient and to some extent read the minds of the people that are engaged in the disputes so that you can bring them together to meet a resolution. In 2019, there was the Singapore Convention on Mediation. It's known as the United Nations Convention on International Settlement Agreements resulting from mediation. When this convention came to light, almost immediately about 54 countries, including Nigeria, signed to it with the expectation that the practice of mediation will take a radical turn, will take a turn for the better, because mediation as we knew it, they said is non-binding. But a step has been taken towards making mediation binding on the parties. So Dr. Rosemary Chikwendu will enlighten us about the 2019 Singapore Convention, and she will also enlighten us about the innovations that the convention has brought to the practice of mediation, such that today we can see it as a way of improving our justice delivery system. Dr. Chikwendu.
Thank you, Leonard Silk. Good evening, Leonard Silks here present, judges here present, senior colleagues, professors, all other protocols observed. Mediation is cost effective. Two of the speakers have already spoken about that. It saves time, it saves faith, and it maintains relationship. The question then is, why is it not the preferred way of resolving international commercial disputes? It's simple. Before the Singapore Convention, there was no unified framework for implementing international settlement agreements resulting from mediation. Why? Nobody wants to subject themselves to the laws of another country. If you come to a country like Nigeria, you have to face the issue of time, you have to face the issue of, we know all our issues. So, what do people do? They go to arbitration. Mediation is faster. You get to determine your own case. It's confidential. But people nations go to arbitration because they don't want to subject themselves to the laws of another nation. And it's because of the uncertainty that it seems as if mediation is the younger brother of arbitration. But it's not. Luckily for us, mediation practitioners, the Singapore Convention has created a unified framework whereby parties can now implement their agreements, except when disputes arise after the agreement. And the issue of enforcement, they now have to go to court. And the convention leaves them with a wide choice of how to do it. The decision is theirs. And there are areas that the convention does not apply. So, what are the innovations that Singapore Convention has brought that will help Nigeria judicial system? I would say that on the face of it, it will seem Nobel, the ideal law, everybody rush for it. All the major economies of the world were the first ones to sign the Singapore Convention. But for ratification, for that law to actually take off, not so much. Because by the time you now study it, you start slowing down. So right now, every nation is waiting to see how the convention will evolve. And it's when the convention starts dismantling that we'll know where it's going. But based on the provisions, one can suggest a few things. Permit me to say that the drafters of the Nigerian Constitution, unbeknown to them, actually reflected the spirit of the Singapore Convention in section 9D, yes, that states that if there's any resolution that arises from treaties between Nigeria and another country, that it will be settled through conciliation, mediation, arbitration, and other ADR mechanisms. So, I'm not surprised that Nigeria was fast to actually sign, but we have not ratified. The reason is that I'm sure that Nigeria, like most countries, are waiting for those big economies that we are quick to sign, to ratify. But on the face of it, based on the provisions, it looks noble. Two people in an agreement get to decide their own matter. Ideally, everybody should go to mediation, because you get to decide your own matter. And nations should go to mediation. One, because you want to maintain that relationship you had with the other nation. I've always believed that there are no two parties that go inside, between going inside a court and coming out of the court, a lot of love is lost. So, if you want to maintain your relationship with the other nation, you have to go to mediation. And the general framework that we have available now is the Singapore Convention. The ancestral model laws on mediation, yes, came out first. Actually, Nigeria was the first country in sub-Saharan Africa to sign the ancestral model laws on mediation, expecting that Nigeria becomes the hub for settlement of agreements in sub-Saharan Africa. But it wasn't going to be so, because, like I said, nations are weary of subjecting themselves to the laws of other nations, because you don't know what you will see. You don't know what to expect. So based on those ideals, I would say that when ratified, because it's not yet ratified, we are still preempting when ratified. When people don't take at least the international commercial disputes are not taken to court, one is that the matters in court are reduced. That is number one. Permit me also to do a bit of mediation advocacy while we're on it. Because arbitration in Nigeria couldn't have grown as much as it has if not for the New York Convention. And because it is accepted internationally, it has rubbed off on local agreements. So, it is our wish, we mediation practitioners, that the Singapore Convention gets cracking so that it has elevated mediation to the same level as litigation and arbitration, so that we'll be very busy and so that we get to earn a lot of fees. Mediation generally, if we leave the Singapore Convention for a minute, mediation generally will reduce the number of cases in our courts. I want to ask lawyers to please start adding mediation clause in your agreements, in your contractual agreements, because it will reduce a lot of cases in the courts. I am also of the opinion that Nigerian laws should have a way of making it mandatory that litigants should go through ADR of any sort before they go to court. Lawyers, you get to earn your fees, because I know it's all about fees. I'm earning my fees as a mediator. So you get to earn your fees, you get to dispense of the cases fast, and you get to see your client happy.
It's time. It's time.
Thank you very much.
You can round up, please. You can round up.
I can round up, yes. Okay. So, applicability of Singapore Convention, where does it apply? It applies only to international disputes resulting from mediation. It applies to parties that are from different countries, or their place of business are from different countries. So, while it's not the local law, I know that just as New York Convention rubbed off on the local practice of arbitration, Singapore Convention, when ratified and we start implementing it, will rub off on local mediation practice in Nigeria. Thank you.
Thank you very much. Thank you very much. I think we have thoroughly been enlightened on the wisdom behind imbibing the methods of ADR, particularly arbitration and mediation. We have received a number of questions from the Woover platform, and we have just about 20 minutes left. And the way I want us to round up this session will be that we will take 3 questions from the audience, and I will read out the questions that are on the Woover platform for the speakers, so that when they are responding, they can have that in mind and also provide answers to them. Mr. Aderemi. We want a lady too, not all men raising up. Mr. Aderemi, can you ask a question, please?
Thank you. Thank you, moderator. Good afternoon. My name is Tolu Aderemi from the law firm of Perchstone and Grace. My question is to the very last speaker before the moderator mounted the rostrum. And it's about the advocacy for mediation. I listened to you very carefully, and I see and indeed share in your optimism that when ratified, the Singaporean Convention will impact on local laws. But let's interrogate the applicability of and the enforcement of mediation itself. And I say this because there are quite a number of commercial lawyers here who are very happy to replace conciliation in dispute resolution clauses with mediation and indeed arbitration. Can you hear me, madam? You can't hear me?
Just ask the question.
Okay. I guess you can hear me, John.
If I understand you, a lot of lawyers, a lot of practitioners, they are more inclined to replacing arbitration and mediation with ADRs like conciliation.
Correct. But I was going to the enforcement of mediation provisions in a contract. So under the Lagos rules, when you have a mediation award, I understand that can be registered in the High Court, and the High Court will pronounce upon that as a judgment of the court. But that must be a mediation process that emanates from the High Court itself. And so when you have an independent mediation exercise, what is the fate of that? That is one. The second question is, what is your view about med-ab? And so sometimes when we have mediation, when it fails, we consider med-ab as an alternative, largely for two reasons. One, you want to save costs for the parties, and two, you also want an individual who is able to understand, weighing the strengths and weaknesses of the parties, as well as assisting them to take a common position. Do you find med-ab a useful ADR mechanism in resolving disputes? I thank you, Mr. Chairman.
Thank you very much. That was a very long one. More of contribution than question. But I'll take it one by one. For the fees, it's simple. The value you place, the worth you place on yourself is what you charge. Mind you, you get to do, because of the level of the practice, you get to do a lot of cost.
Can we do it this way? Excuse me, Mr. Adremi. Can we take all the questions and then the speakers will have 2 minutes each to respond to all the questions that relate to their interventions? So, can we have a lady? Yes, the lady in front.
My name is Abimbola Yoride of the Lagos branch. Please, can we have a body that can act like a disciplinary committee, that can discipline lawyers that are aware of terms of settlement after a mediation? But when we go to court to adopt the terms, the lawyers in their pleadings, we purposefully ignore such terms. And when you approach them to ask, why is that so? They will tell you the judge has not ruled on it. The reason why I'm saying this is that I have a matter before the Lagos High Court judge, and it was referred to the multi-door courthouse. Several months, parties went there. Some traveled from Abuja, from Lagos. We had this section for like 8 to 6 months. And large number of the terms was from this party that I'm trying to give this scenario about. And we agreed, and parties signed, and the lawyers also signed. Now, because of that, the judge set down that matter for trial. And while going to court, I just noticed that the other lawyer refused to come to court after serving him several hearing notices. So the lawyer called me to inform me that his client has actually disagreed. He doesn't want to go by our terms. Now, another lawyer was briefed on this matter. He filed another pleadings and totally ignored the terms. While we were in court, I asked him, "Are you aware of this document?" The answer was, "Yes, but the judge has not ruled on it." The reason I'm asking this is that maybe we should have a body that can discipline lawyers that purposefully do this, because I know that we wasted like 6 or 8 months. The essence of alternative dispute resolution has been defeated.
Thank you very much.
Thank you very much.
Your point
sir.
is made. Any questions should not go more than 1 minute, please. I'm going to take another man, but for gender sensitivity, I will balance it with a second lady. Mrs. Obifarinde.
Thank you. My name is Morenike Obifarinde. I'm a mediator. And I just wanted to add to what she said about mediation. We actually have in the rules of professional conduct rules enjoining us as lawyers to tell our clients about ADR. It is mandatory for us as lawyers, Rule 19 of RPC, to tell them, to give them the option of ADR. Just to add to what...
Thank you very much. That's not a question. That's a contribution. Thank you very much for the contribution. We'll have a second gentleman, the man in cap. In cap, you are wearing cap now. You are the one I'm talking to. And the last lady will be from my right here.
Okay. Thank you very much, sir. It's Mark Sikongbe from the Abuja branch. So what I want to ask is the cost of arbitration. What do we do about the cost of arbitration? Recently, a colleague reached out to me and told me he had an arbitration. The claim value was maybe about $100,000 US. And it was a three panel of arbitrators. And each of the members of the panel charged 7% of consideration, excluding administrative costs and some other associated costs. So essentially, 21% or maybe 22 or 23% of the value of the dispute was being charged by the arbitrators. What do we do about this, about the scale of fees? Because I know in India, they have to even pass a lot of cap fees. Do we go that way in Nigeria, or what options do we have? Thank you, sir.
I'm sure Mrs. Ufort will address that, but I doubt if a tribunal can charge 21% of the cost. Can we have from the right here? Come on. Yeah.
Thank you very much, Mr. Moderator. My name is Omolola Ikwagu, George Ikolia Nokagwe. I noticed that at the beginning of the presentation, Mr. Etigwe Uwa made reference to the fact that interlocutory applications should stop or should end at the Court of Appeal and not go on to the Supreme Court. This is a call that has been repeated several times at several fora. What can we do to make sure that this does not end with this presentation, that action is taken to translate it into amendment of the Constitution? Secondly, Another observation which has been made here is that senior practitioners and arbitrators engage actively in frustrating the essence of alternative dispute resolution by engaging in spurious applications to set aside valid and well-reasoned arbitral awards. Most of these arbitrators belong to bodies. We have the Chartered Institute of Arbitrators in Lagos. We have the UK branch also in Lagos and in Nigeria. And we have other arbitral bodies. What can these different arbitral bodies do to call their recalcitrant members to order?
Thank you very much. So I'll go on the Wover apps and I'll read out some of the questions we have there. So our speakers will take notes, and when the mic is given to you, you respond to the questions that you want to provide answers to. The first one, why is there can ADR be used in criminal matters? One, in what areas can ADR be used in criminal matters? Can ADR be used in criminal matters? Why is there not a provision for the accused or his counsel held in detention to apply for the legal advice to be made available to the magistrate court timeously under the rules of court or administration of criminal justice system? Second question, utilizing the same approach of court case duration regulation through an extant law, such as in election matters, the country's justice administration will improve, complemented, although by ADR. Isn't this option practicable in Nigeria? Third, is it possible to mediate all cases? What can be done to improve on the speedy conduct of dissolution of marriages in Nigeria, particularly which one of the parties reside overseas? That is irrelevant to the first one. The first one. Possible to mediate all cases. I've been told to just whisper into the microphone. Can you hear me? Can you hear me?
No.
You can hear me?
Yes, can you hear me?
If you are saying no, that means you can hear me.
The microphone.
Okay, is it okay like this? Is it better? Is it better? Okay. What are the appropriate mechanisms to tackle the delay in the administration of justice? I think that has been addressed. What are the causes of delay? That has been addressed. What happens where serving judges are excluded from election petitions in Nigeria? I think it is pertinent to institutionalize day-to-day trials. I also believe there must be a system of sanction in place to discipline those responsible for delays. When is our prison going to be privatized? So, of all our prisons, when are they going to be privatized? So, I will start with Mr. Madumere. You have a minute and a half.
Thank you very much, Mr. Moderator. I want to take the last question, second to the last question that was asked, which is, can ADR be used in criminal matters? You will recall during my presentation, I had made a suggestion, and I will simply refer us to Section 14.2 of the Economic and Financial Crimes Commission Establishment Act, and it provides as follows. It says, subject to the provisions of Section 174 of the Constitution of the Federal Republic, the Attorney General which relates to the power of the Attorney General to institute, continue, take over, or discontinue any criminal proceedings against any person in any court of law. The Commission may compound any offense punishable under this Act by accepting such sums of money as it deems fit, exceeding the amount to which that person would have been liable if he had been convicted of that offense. Section 76 of the Administration of Criminal Justice Law of Lagos State provides as follows. Notwithstanding anything in this law or in any other law, the Attorney General of the state shall have power to consider and accept a plea bargain from a person charged with any offense, where the Attorney General is of the view that the acceptance of such plea bargain is in the public interest of justice, and the need to prevent abuse of legal process.
10 seconds more.
Obviously, this law allows, for the AG, to use other means of mediation, which is the, criminal mediation, to resolve criminal matters. So the answer to your question is yes. On the basis of this law, the AG of a state or of the federation can mediate a criminal matter and resolve it, and it's been used frequently.
Thank you very much.
Thank you, sir.
Dr. Chikwendu, you have 90 seconds to respond to the questions that has been directed at you.
The first question on mediation agreement from private, he said that was what he asked. Because I really can't hear you.
I've read all the questions. I know. I thought you were taking notes when they were asking the questions.
Yeah. No, I was not.
Okay. Mr. Itigwewa, you want to respond to some of the questions?
Yes. Let me respond to the private mediation agreement. Because mediation is hinged on self-determination, you get to determine the outcome. The mediator does not determine the outcome. The mediator is just there to facilitate and encourage you with the skills they have to keep talking till you reach a resolution. So most of the time, people honor the agreement, most of the time. But when it's not honored, it's a binding contract. That's when the courts come in. But I know that 90% of mediation, people get to honor their commitment. That is one. You also asked about MedApp.
Time up.
Okay.
Thank you very much. I'll move on to Mrs. Dorothy Ufotese to respond to any of the questions that has been put to you. 90 seconds.
Well, I think most of the questions were on mediation. So I will set my own question and answer.
No, it's all right. If you will still have opportunity for a closing remark.
Sorry?
You will have an opportunity for closing remarks.
Okay.
So let's go on to.
Sorry? It's echoing too much.
I said all the speakers will have an opportunity to make a closing remark.
Okay, so I pass the mic to.
Yes. Yes. Thank you very much.
Well, I'm sorry, at the time when the questions were being asked, it was very difficult to get most of the questions, but I'll attempt because I took some notes. The first question about private mediation has been answered. There was a question about whether there is need to discipline lawyers who ignore terms of settlements reached during mediation and advise their clients to take hostile proceedings in spite of the terms of settlement. I think it really depends. Normally when you enter into terms of settlement, you shouldn't be able to appeal against it except you show fraud. So it depends on the base on which such a lawyer is attacking it. But if it is clear that the lawyer is doing something which is wrong, or he's just trying to use delay to prevent his client from meeting his due obligation, that might be something that the legal practitioners disciplinary committee might be able to look into. Somebody asked the question about the cost of arbitration. That's something which is important. You find that arbitrators are expensive, and Mrs. Dorothy Ofort was talking about the effort of some of the arbitration bodies to reduce the cost of arbitration. But one of the things that we can do, we can borrow what we did in the legal practitioners' remuneration order. If we have the appropriate statutory backing, maybe there can be a scale of fees. And one of the things that can also happen is if we take a lot of matters and push them to arbitration. I'll give an example. Cases which customers have with the telecoms companies. You will find that by the very nature of telecoms contracts, those amounts will not be huge. So, but because you have over 100 million Nigerians who have access to mobile phones, you would have a lot of quantity. So there is a way in which you can, through statute, push most of these kinds of matters to arbitration and provide a scale of fees. The arbitrator may not earn so much, but the volume might make it something that is worth his while.
Thank you very much. Time is up.
Well, there are some other questions, except if you want us to leave them.
Because we have to round up. Our time is, we have just 45 seconds left.
Okay.
Yeah, I think for the gentleman in car, it's not possible for an arbitrator to just say, I charge you 21%. There is a scale of charges. There are international standards. There is ICC scale of charges, there is a Chartered Arbitrator scale of charges, there is the AA, there is the IB, loads of them. So an arbitrator cannot arbitrarily say this is how much I'm charging you. So you need to know about your practice. I'm not saying you should name the names or give any names, I'm not doubting you, but it helps to be enlightened so that if you are confronted with such situation in the future. Secondly, there are institutions offering small-scale arbitration now, small-scale mediation and small claim mediation and small claim arbitration. The Lagos Court of Arbitration and a number of them, you can submit to them. Lagos Court of Lagos Multi-Door Courthouse. They handle small claims. Kano Multi-Door, Abuja Multi-Door. So unfortunately, we have to round up because the red light is flashing. So I will give the speakers just 30 seconds to give a final word, a note of parting, before I call on Professor Akeredolu to give the vote of thanks, and then we close the session. Let's start with Dr. Chikwendo. Just 30 seconds.
Thank you very much. I'm still of the opinion because when each of us made their presentation, everybody was like protecting their turf. I'm still of the opinion that mediation is the way to go.
Thank you very much. Can you hand over to Mr. Awa? Yes, sir.
I think that ADR can be part of the answer to deal with delays amongst other things that can be adopted. I find that the way things are practiced in Nigeria, sometimes you go to arbitration and then you start going to the Federal High Court, the Court of Appeal, the Supreme Court, and it becomes an additional layer, it becomes more expensive, it becomes more time consuming. I think we need to have a policy like they have in England where it's almost impossible to set aside an arbitration award except you can show fraud or some very, very, very egregious conduct on the part of the arbitrator. If we do those, then ADR will be one of the ways in which delays can be cut down. But not every matter can go to ADR.
Thank you
not
very
everybody
much,
can
Mr.
afford
Awa.
it.
Thank you very much. Can we have Mrs. Ufort? 30 seconds.
Thank you. Given the background of the discussion, whether ADR or arbitration is the answer to the delays in the administration of justice, I would say conclusively as an arbitrator that I think that if we deal with the challenges of arbitration, which I earlier referred to, that we are trying to deal with it, even in the Nigerian situation, I would conclude that arbitration, particularly for complex commercial high-volume disputes, it can only be arbitration anywhere in the world. But in Nigeria, for the international arbitration community to reckon with us, one of the challenges that we have to deal with is the perception of corruption. Thank you.
Thank you very much.
Thank you very much, Mr. Moderator. I am of the firm view that once the legal framework supports ADR practice in Nigeria, and once practitioners and the judiciary receive appropriate trainings, that the effectiveness and efficiency of ADR in this country will be enhanced, and the support, effectively also in administration of justice. And to answer the questions asked by somebody as to what MEDAB is, MEDAB simply means moving from mediation to arbitration. Usually that's reflected in the clause in a contract, which says that parties will start by mediation. Once it fails, they move on to arbitration. And to answer the question you asked, yes, it's an effective way of alternative dispute resolution. Thank you very much, sir.
Thank you very much. Can we give all our speakers a round of applause, please? Delays in the administration of justice. Are alternative dispute resolution mechanisms the answer? The answer can be yes, but only if we change our approach and only if we change our attitude. There is nothing wrong with any method of ADR. There is nothing wrong with arbitration, but the way we practice it is what is wrong. I'm guilty. The speakers are guilty. The audience is guilty. Let us look at what we need to correct so that what should be an advantage will not be converted to a disadvantage and contribute more to the delays in the administration of justice. On that note, I'll invite Milord Justice, Professor Mrs. Akeredolu, to give the vote of thanks. Thank you very much.
So on behalf of the Nigerian Bar Association, I want to say a very big thank you to all the members of the panel. Let me start with Dr. Rosemary, who we both belong to the Women Mediators of Nigeria together before I joined the bench. So I was quite confident that you were going to be in support of mediation here. Thank you very much for coming. And my friend who reminded me that we are friends, we are still friends, Leonard Silk, Etigwe Uwa, thank you very much for speaking your mind, even though the Leonard Silk was trying to cut your time. But as the senior that you are, you spoke what you needed to say. Mrs. Ufot, Leonard Silk, like I said earlier to you, it was a pleasure to meet you for the first time, even though I've met you severally online and at other fora. But thank you very much for the arbitration work you do in Nigeria. Thank you. And the moderator is my friend and brother from Ibadan. So, Leonard Silk, Tunde Busari, thank you. Thank you for doing a great job of coordinating the session and making sure we kept to time. That was quite right. Thank you so much. And last but not the least, I'm sorry, I forgot it. Oh, yes, sorry. Mr. Chikwendu Madube. Yes. Thank you very much for that contribution about MEDAB. And all the panelists you spoke, I'm an ADR person myself. That's where I have my professor, my chair, and currently the ADR judge in Ondo State. So you know that the multi-door courthouse is a mixture of both. We offer everything. So I'll say that everybody, you can continue to use that. And thank you everyone for a job very well done. Thank you. God bless you. Right.
Thank you very much, my lord. We have now come to the end of this panel. Thank you very much for staying with us. We'll have pictures now of the panelists, please. Yes, please, thank you.